Hey everyone, I'm David Finz. And on this episode of the Cyber Insurance Imperative, we're going to turn our attention to the world of artificial intelligence, and more specifically, what the European Union is doing in this area. Because as we've seen with GDPR, what Europe does will eventually find its way to the US. In fact, California is already proposing some new regulations around the use of AI. So earlier this month, the EU Parliament reached an agreement with the European Council Presidency on new rules for artificial intelligence. The main new elements of this provisional agreement include rules on high-impact AI models that are intended for general use but may cause systemic risk, revisions to the system of governance for AI with some enforcement powers at the EU level, prohibitions on certain uses of AI, with some exceptions for law enforcement, and perhaps most notably, a requirement that deployers of certain AI systems that are deemed to be high risk conduct a fundamental rights impact assessment prior to the rolling out of the system. Think of it as a sort of environmental impact statement for AI, only with a focus on human rights. There will be an elaborate governance system set up with an AI office to establish standards and testing practices, a board comprised of member states responsible for implementing regulations, and an advisory forum for various stakeholders. Also, certain uses of AI are considered too risky and will be banned from the EU altogether. These include cognitive behavioral manipulation, untargeted scraping of facial images from the internet or closed-circuit TV, emotional recognition in the workplace and educational institutions, social scoring, biometric categorization to infer sensitive data such as sexual orientation or religious beliefs, and some cases of predictive policing of individuals. As far as penalties for noncompliance, much like GDPR, these will be calculated using a percentage of a company's global annual revenue or a predetermined amount, whichever is higher. Under the AI Act, fines could run as high as 35 million euros or 7% of annual turnover for violations of the banned AI applications, 15 million euros or 3% for violations of the AI Act's obligations, and 7.5 million or 1.5% for the supply of incorrect information. However, there are plans to provide for more proportionate caps on administrative fines for small and mid-sized businesses and startups for infringements of the provisions of the AI Act. Now, private party litigation is not as prevalent in Europe as it is here in the States, but the compromise agreement also makes clear that individuals or other parties will be able to file a complaint with their member states' authorities and can expect that the matter will be handled accordingly. This is similar, say, to when an employee here files a charge of discrimination with the EEOC and the agency then investigates it, the only difference being that the private party here could still proceed in court. So what does this mean for our listeners? Well, assuming that the European Parliament ratifies this agreement, if you conduct business in Europe, you will have 2 years from the Act's entry into force to get your house in order before this takes effect. But even if you don't conduct business in Europe, what's happening there is instructive. As I mentioned, California has already proposed regulations around AI, and the framework that has been drafted by NIST, or the National Institute of Standards and Technology, provides some helpful guidance around governance, mapping, measurement, and management of AI. This is only a draft, but it should get companies thinking about the kinds of risks the use of AI presents and what they should be doing to develop internal policies that can help reduce those risks. Here at Alliance Cyber, we are on top of these developments. Our risk consulting team is prepared to work with your business to assess these risks and develop appropriate policies, and our brokerage team can help you anticipate where insurance coverage might come into play around the types of losses that may occur. And I should note, it's not just about cyber. In a previous episode, I noted the ways in which media liability, employment practices liability, and professional liability could all be implicated by the use of AI. Even property and casualty policies might need a review in light of your planned usage of AI models. To arrange for a consultation with our team, you can DM me on LinkedIn or email me at david.finz@alliant.com. It's just one more way of helping you find the more rewarding way to manage risk. Thanks for watching.